One's going to be on the, oops, we're live here on Friday, May 1st, 2026. Uh-oh, the rent and the mortgage are due today. May 1st. We have some committee discussion time for this morning that we'll see where that goes. And then Damian is available at 11 when he gets done downstairs. So we're shortly after 11. We'll have our ledge counsel in the chair and we'll see what else we can sort of button up and thumbs up on the bill and get it down to what's left to work on for next week. And we will definitely be done with it for next week. So that's the plan anyway. No new information on potential, ending dates or anything. So there are no deadlines to get given to the House chairs to get their bills out. But we're not going to be anywhere near a reason to hold up the show. So we spent some time on vehicle inspections. There's two parts of the vehicle inspections that I'd like to hear if people have thoughts on and whether we need more testimony on and whatnot, particularly related to the section 24, I believe it is, on sort of the inspection rewrites. But also this issue when we passed out our T-bill, the House version, it requires that through we set up mileage-based user fee that a battery electric vehicle would need their inspection in order to get their odometer reading to settle up their fees. And then that discussion eventually, after, even though we passed the bill up, it didn't come out at that time. But it really in the last couple of weeks, one of those things that's come up is whether or not inspections would be required before registration for all vehicles. And kind of curious, I don't know if we can or can't get enough testimony and figure out and whether or not they would be ready to implement such a thing, or we should maybe send a message about bringing it back to us for next year. But anyway, before we decide what we're going to do, I'm kind of like to hear a little more if there's people that want to share opinion on the idea, because we certainly, it came up a lot over the last week or two that, but for some reason it didn't come up when we had the T-bill. So we probably had a better opportunity then to do something. But that doesn't mean we shouldn't queue it up for the agency to work on or the department to work on. Anyway, I'm not trying to say what we should do, but I am interested. And I do want to caution that we probably missed our best opportunity back in T-bill. But that doesn't mean it's not. I want to find out if it's the thought of what more we should explore and whether we think it's valuable or an important policy discussion and decision. So that's what that one. And then what about the changes that are recommended for reducing or focusing the inspection on safety? That's the second question. Want to go first, Representative Bauer?
Sure, yeah, as usual, I have plenty to say. I mean, I think we did talk about when the mileage-based user fee came and it was explained, hey, we asked the question, hey, what happens if people don't get inspected? And that's when it came up that, we were told, I believe, oh, you're not going to be able to re-register your car unless you're inspected. And we asked, can you do that? And I thought we were told, yeah, it's not that difficult with the new system. And I think Rep. White mentions, well, why wouldn't we do it for everyone at that time? So I think we should really explore it. And it isn't going to happen. I'm not sure. I'd have to go back and look at the bill, the way it's written, but the mileage-based user fee, that piece of it requiring inspection to get registered to make sure people are getting their mileage in, I don't think starts in January of 2027. I think that's when the mileage-based user fee, but that registration piece verifying would be the next year, and I think that'd be plenty of time to incorporate this piece into it.
So because it's not going to be implemented in the way the version of the Senate, you're not going to start until January of this year.
The timing changes, yeah, and that would give plenty of time and warning for everyone to know, hey, by the way, and it will give the DMV and anybody else who says, oh, this could be a real problem, time to come back and say why it's a problem. But it seems it's the law, it's required. If it's going to happen for electric vehicles for the right reason, then it seems like it should happen for everyone.
Opinion, Representative White?
Yes, I mean, I think we don't quite know what the final MBUF will look like until the conference committee is looking at it. But I think Rep. Couch is correct in that we were saying it's gonna start January 2027. And I think that the required inspection will kick in after that. Maybe that's January of 2028. So I think that timing wise, whether there's an opportunity to put something in the DMV bill or to put intent language in the T bill, or I'm not quite sure the best way to signal that this is something that we are hoping the next legislative session takes up. But I think that makes a lot of sense. It would give the department some time to think about how they would implement requiring an inspection for all vehicles and think through notifying the public that this is going to be happening. And at the same time, we've been talking about changes to the inspections in the DMV bill, which, honestly feel to me like they could use the changes proposed could use some more thought in terms of, are these all the right changes we want to be making? I've expressed before, I'm uncomfortable with the emergency timeline for pushing these through so quickly, particularly given that I personally don't feel like all of these changes are in the right direction. I mean, we talked about some of the changes that some of us had issues with yesterday, so it just feels a little rushed to me. And but I certainly appreciate the department's sentiment to try to respond to Vermonters' requests that inspections are expensive. So, I think the goal of looking at inspections and focusing on what is essential and what is things we can live without, that's an important exercise that I don't feel confident in voting for those changes in this bill right now. So I'd like to somehow amend that language so that there's more time to, whether it's go through rulemaking or whether we just have more time to discuss and take testimony on some of the specifics of the inspection changes proposed. I'll stop there. I think was that clear?
Did we, listening, we're setting off in a couple different directions. Did we hear testimony as to how many percentage of cars that get a 2-year registration versus a 1-year registration? That takes us off of your comments on the wrong direction, but back to the comments about implementation of NBUF and timing. Did we hear like what a percentage we did at one point? I didn't.
We heard it, and I recall, because I was sort of surprised that there were, I think it's one.
Way more 1 years than 2 years.
Than 2
Yes,
years.
I always thought that
I
I
never saw it.
2 years because, you buy a newer car, it's gonna last for 2 years.
Yeah, yeah.
You think you go with the 2 years cheaper, but it was a,
Yeah,
was
I
a lot
was
of percentage
surprised,
in 1 year.
yeah, I was surprised.
Because I was wondering how that might impact if you have a 2-year registration, so I'll leave my car inspected every other year.
Yeah.
I'm not, because so there are always, as we know, there's no such thing as simple, right? So there's nothing, there's gonna be, and that's one of the ones that comes to mind. What's the difference between a 2-year and a 1 year? And, we did hear the testimony about whether or not we're gonna expect people to, is that gonna, have a negative impact on the amount of registrations, unregistered vehicles running around, but that's a whole nother topic. But I was wondering if anybody remembered the percentage of 1 year versus 2 years.
I just remember it was higher.
I do remember it's a challenge to calculate what the, how much it's gonna come in, because you don't know on any particular year how many 2s and how many 1s, particularly when it started. It may be settling down now where they can sort of predict it. Like Logan had said, that always a cautionary, it's hard to tell when there's ability to do multiple years on different things like getting your registration, what the income will be in any particular year. But it's been several years they can do that. I think by now it's probably settled out a little bit.
it would be a hurdle for them to do necessarily. I don't know how much, I don't want to encourage people to not get their annual inspection. But, on the other side of the safety part on your comments, we did commit to the body, we were going to do something on inspections. I don't know, sounds like you're, feel like this may not be enough, or it may not be the right path. I know other people have opinions on that at all, but you're certainly welcome to go again.
Yeah, you know, on that piece, yeah, it feels, I don't know why we don't just go through rulemaking. We know there's a lot of opinions on inspections, from don't do them ever to they're not stringent enough, and never mind, people aren't getting it done. I haven't heard any reason why we have to rush this. The rulemaking's just gonna add a few more months to the process. And, you know, even we had questions about a few of the changes that I've proposed. And I don't like the idea of making those changes, then going through rulemaking and then, you know, having to defend them. And, yeah, I think, you know, we got plenty of opinions on it. We get everyone's opinion on the table and go through the proper rulemaking process. And if we can come up and simplify things, great. You know. And I haven't heard a good reason why it's an emergency to not go through the normal process.
Representative Casey, and then Representative Burke.
I'm fine with the changes and the, in case anybody gives a sweet darn, but and I'd like to see it go to 2 years, inspections. In my opinion, I'm done now.
Representative Burke.
Yeah, well, I agree with Representative Couch. I am a proponent of every year inspection. We discussed.
I didn't hear that clearly.
Oh, sorry, I'm a proponent of once a year inspections. For a lot of reasons. I think safety issues. I think affordability, because it catch things early. And then there's the emissions.
I think what's being discussed is these changes.
Yeah,
It's Representative McCoy.
So the changes that we heard yesterday. Are you saying they have to go through rules as well?
Well, those are the proposed changes they want to do. Not going through rulemaking, using this emergency piece. And even, but after it's done, it will have to go through rulemaking, but it'll be after the fact, I think.
To be clear.
You're welcome to come on up, because we're gonna have you for the other, well, you're early.
For the record, Damian Leonard, Legislative Counsel, both are through rulemaking. One uses the emergency rulemaking procedure, one uses the standard APA procedure. So they're both under the Administrative Procedure Act. Emergency rulemaking allows the agency to adopt the changes without having to go through sort of the notice and comment period in the middle, so they can implement them. But that emergency rule can only be in effect for 180 days. And so during that time, they can go through the more permanent procedure, which also allows them to tweak the changes based on feedback from inspection stations and the public. As people go through these inspections, they'll be able to do notice and comment. So just to be clear, both are rulemaking.
So that they would have 6 months of experience with the new changes to impact and adjust. They still have to go through.
Right. There's nothing that says
6
they,
months of information.
yep. There's nothing that says they have to make a change, but they can make the change.
There's no guarantee that the rules that, and you go through 6 months, you still have to then do the rulemaking. They can change during that time frame again.
Yeah. So
So it
with,
won't necessarily be exactly what's done here. You still would have to go through the process. They would have 6 months of experience to head into that process.
right. So with the rulemaking process, typically what happens, and especially when you have an emergency rule, what happens is you have the emergency rule and the proposed final rule filed at the same time. The proposed final rule typically looks identical to the emergency rule. Sometimes there are minor differences because of the timing, but typically they're the same. And what happens is the agency then has that 6-month period, and typically rules take 4 to 8 months to get from start to finish. They have that 6-month period to go through the process of making the rule available to the public, to the folks who are impacted by it, taking comments on it, including at a public hearing, and then proposing changes to it, at which point they submit the final proposed version to the Legislative Committee on Administrative Rules, who then reviews it for conformance with the statutory authority of the agency, legislative intent. Did they engage enough with the public? Did they conduct an appropriate economic impact analysis, et cetera? There are things they're required to do under the APA. That process often includes points where folks have, if there are changes, they also have to comment on why did we make these changes? If there were comments requesting other changes that they chose not to make, why did we choose not to make those changes? And then when you get to LCAR, there's another review by Legislative Council and the committee. And the comments are focused primarily on conformance with the statute and the legal authority, but sometimes there are typos that are caught and other things like that. And then after all of that, there's a final rule that goes to the Secretary of State for adoption.
Can I continue my questioning?
Yep.
Okay,
Sorry.
so,
That is true.
so can the DMV update their inspection manual and go through the administrative rule process without this section in the?
Yes. They have authority right now to
To do
adopt the
this.
rules. What they can't do is do the emergency rule.
Okay,
So
if we
That was my
remove this section,
Yeah.
if we remove this section, then they would go through the regular administrative time frame of 4 to 8 months as opposed to maybe a 4 month.
So, yeah, with emergency rulemaking, they could adopt it as soon as they get, what this does, typically emergency rulemaking requires an imminent threat to public health or safety. And so we waive that in instances where it's not there, but we have to do that through legislation. Otherwise, LCAR doesn't even get a chance to get to, does this rule make sense? They say this rule doesn't meet the requirements for emergency rulemaking. And so we have to object on that basis. Whether that ends up resulting in anything, is another question, but under the statute, you're supposed to limit rulemaking to that. And there is one other exception for federal or multi-state compacts where we have to adopt the rules quicker than the rulemaking process. But they have existing authority to update and amend the inspection manual. What this sets out is guidance for what is being proposed, but my understanding is DMV was already working on these amendments, but would like to roll them out sooner rather than later. There was also discussion in the Senate about taking these amendments out of the required APA process and allowing DMV to do it as a procedure, which we've done for other things, such as multi-state lottery rules.
And bypass LCAR. Yeah.
Bypass LCAR altogether. The Senate was not open to that, or the Senate Transportation Committee was not open to that option. So that was something else that was discussed downstairs, and I can't speak for DMV, but my understanding is there was thinking that would provide more flexibility and more ability to be nimble with rulemaking. The Senate was concerned about losing legislative oversight over the inspection manual, which is, that's the rulemaking requires public engagement. When you take it out, you lose that public and legislative engagement requirement. It doesn't necessarily mean that the agency stops doing it. but you lose the statutory requirement for those steps. So the Senate wasn't comfortable with that. You may have different feelings.
Yes.
Yeah.
That last part is not what's being proposed here.
No, what's being proposed here
We're not
is
talking about bypassing entirely. We're talking about jump starting it.
jumpstarting with an emergency rule to allow it to roll out quicker, but still requiring it to go through rulemaking.
So it's still, yeah, you're gonna end up in the same place, whether you get 6 months of relief from waters and data or information and then the changes. So this bill does not propose skipping.
No, it doesn't.
Just a clarification, I'm trying to just get it straight in my head, as far as this emergency, because we hear all the time, the governor has the authority to do emergency rulings, implement things. The commissioner of DMV just suspended temporary plates on his own accord, and we need to make it permanent. So why do we need, why does the legislature need to be the determination whether or not it's an emergency through legislation? How come the governor can't do it?
So the governor and the agencies are part of the executive branch, and the executive branch constitutionally, their job is to execute the law.
Yeah.
It's literally where the term comes from. The Constitution provides that the governor shall carry out the laws as written. And the legislature makes the laws. We've provided flexibility to administer programs because understanding that this is a part-time legislature and legislation takes time, we've provided flexibility. That said, the executive branch can't simply override the laws. And in this case, we've said that in order to update the inspection manual, you have to do it through rulemaking. You could change that.
No, I'm just wondering, I'm just trying to
And
think of
then
emergency, the governor, Irene, on her, machines going on the river. That was an emergency room.
For things where we've required rulemaking, we've basically provided exceptions that allow the executive branch to impose an emergency change to rules in specific situations. And this is basically the separation of powers between the legislative power and the executive power and the judicial power. It's not like a black and white separation. There's overlap. But when we're talking about rulemaking, which is a delegation of legislative power, so we delegate the authority to fill in the details after the legislature has painted the broad strokes, understanding that DMV has more expertise in car inspections than, the legislative committees charged with overseeing transportation do. Within that, we've said that you have the authority to adopt these rules, but we want you to go through this public process. And we've said that you can update rules without going through the public process in these limited scenarios here. So the governor's executive order authority and the agency's authority to temporarily suspend something come from this sort of idea of there's a balance here for limited time scenarios where you may need to take emergency action. With the governor's emergency action authority, much of that is set out already in Title 20. Chapter 1 of Title 20 sets out emergency authority for the governor. And then within Title 23, there is language setting out discretion for the commissioner of DMV to implement things. And I think that can arguably be read to encompass the temporary suspension of those plates when fraud was determined, similar to what's happened in the past with ways that you can apply for unemployment insurance when they determine that fraud was occurring in other instances. But ultimately, if you're going to make a permanent change to the laws necessary to make that temporary change permanent, then you need to go through the legislative process. And so this is similar to what's been playing out with some of the governor's executive orders to increase housing. There was an attorney general opinion that came out in the fall following the executive order that said for some of these things, this is really, it needs rulemaking or legislative authorization to go forward. It's not something that lies within the executive's power, whereas for other things, there may be things the executive can do within their power. And it becomes this, it's not a clear line, and there is push and pull, but when we're talking about rulemaking, that is a delegation of the legislature's authority to the executive branch. And then it's got certain guardrails around it. You could change the emergency basis, and we've done that to allow for fish and game. There are federal bag limits on migratory birds each year. We get them so late, there's no way that Department of Fish and Wildlife could update the bag limits. So we've provided an exception for them to do that. For Powerball, we've provided an exception. In this case, we're providing a temporary one-time exception to get through that, and then keeping the guardrails that say otherwise. We're limiting it to things like COVID or to Hurricane Irene or something like that, where there's a clear imminent peril to health, safety, and welfare. And we're saying, when that's the case, have at it, because clearly the executive is much quicker.
So
and
we're,
more nimble
look at, we're
legislature.
lowering the bar, raising the bar as far as that threshold of what emergency is.
So exactly, we're not changing that bar permanently. We're simply removing that bar.
No, well,
in
we're
this
setting
case.
precedent. Somebody can point to this and say, well, if this is what they consider emergency, why isn't this?
So we're saying notwithstanding the statute.
Well, yeah, exactly.
Just one instance.
The legislature, they're in effect, I read it as to, they're in effect saying, we want the legislature's permission to make sure it's okay for us to.
No, correct. And then, somebody comes in next biennium and says, oh, that's the threshold for emergency. So we should let, administration do X, Y, and Z because that's the new bar. Right now, emergency is pretty like Irene, the whole state.
The threshold for an emergency is set in statute.
Yeah.
What we're doing here is saying, notwithstanding the statute in this instance,
Right.
we're deeming this,
Somebody could point.
we're saying that this meets the standard for emergency rulemaking.
Right. One could say that that's a new standard for, you can point
The
to.
notwithstanding language means that this isn't precedent that carries over to other instances.
Oh, I would point, no, not even, but I would definitely point to that. If I'm trying to do legislation, trying to get something, notwithstand, yeah. You're gonna say.
You could say
Yeah.
there are instances you've done it in the past, and I would say to you as your attorney that in each instance, when it's been done in the past, and we do this every year in 2 or 3 bills, in each of those instances, it is carefully considered by the legislature and determined that in this case, we're willing to suspend that requirement. And it's a case-by-case evaluation.
It's somewhat common. It's happening.
It is, so, yeah, I would say, well, maybe 1 to 3. But I would say in recent years with the emergency housing program, every single year that's authorized in the budget and reauthorized in the budget each year. And this year they're proposing a different construct. But each year that was authorized in the budget, it came with a waiver of the emergency rulemaking standard so that they could adopt emergency rules and implement the program in July. Because understanding that to get their permanent rules out, it took until January of the following year, followed by potentially a couple of months of wrangling if there was disagreement about whether their rules were consistent with legislative intent. And so each year they waived that for emergency housing, and that has happened for years. We used to do it with lottery on a multiple times basis until they simply created a permanent exception for the lottery. Because Powerball and Mega Millions will update their rules at least once a year to make the odds a little bit longer on the jackpot. You didn't hear that from me, but that's why the jackpots keep getting bigger. You're more likely to win a small prize, but the long-term prizes get a little bit harder.
Getting nervous. I haven't won yet. My retirement plan is close to the retirement plan. Representative Burke and then Representative Pouch.
I just wanted to comment that, we're having this discussion with a different scale, federal government, but that relative power of the executive over the. We are indeed.
Yeah, I do want to be clear.
The unitary executive.
I do want to be clear that these exceptions, while they are not uncommon, it's not granted lightly. So if you're concerned about this exception, like that's a valid concern. And if you're concerned about this becoming something that future transportation committees are told, well, you've done this, multiple times before, that I don't want to invalidate that concern. I just want to say that this is not unusual and it hasn't become sort of a binding precedent for those committees. It becomes a case by case thing, although it does get pointed to.
A comment, then a question for council. My comment is if we make these changes using the emergency rule, so for example, no test driving is necessary anymore. We could argue one way or the other whether it is. But once you do that, all the inspection stations are now allowed not to do it. And if through the rulemaking process, there's, a lot of input that says, no, it is important. We heard some testimony saying, oh yeah, it's kind of important. It's going to be hard to go back. That would be a reason, well, we don't want to back there. So that's not a good way to make rules, I think, by saying, here are the new rules. Now convince me they're not good. And then I would ask Ledge Council, is what emergency rulemaking, is the term emergency defined? Like, are there examples of what emergencies are?
Sure. So let me go ahead and pull up the statute. So you find this in chapter 3 VSA chapter 25, which is our Administrative Procedure Act. And I believe it's section 844, but I will confirm that. Right, so section 844, emergency rules. And while I'm reading this to you, I'll log into the meeting so that I can share screen. So what 844 provides is, sorry, getting lag here on my computer. It provides that where an agency believes that there exists an imminent peril to public health, safety, or welfare, it may adopt an emergency rule. The rule may be adopted without having been pre-filed or filed in proposed or final proposed form and may be adopted after whatever notice and hearing the agency finds to be practicable under the circumstances. The agency shall make reasonable efforts to ensure that emergency rules are known to persons to be affected by them. Emergency rules shall not remain in effect for more than 180 days. An agency may propose a permanent rule on the same subject at the same time that it adopts an emergency rule. Emergency rules adopted shall be filed with the Secretary of State and with the Legislative Committee on Administrative Rules. The Legislative Committee on Administrative Rules shall distribute copies to the appropriate standing committees. The rules shall include as much information required for the filing of the proposed rule as is practicable under the circumstances. An assigned and dated statement by the adopting authority explaining the nature of the imminent peril to public health, safety, or welfare, and approving of the contents of the rules. On a majority vote of the entire Legislative Committee on Administrative Rules, the committee may object if an emergency rule is beyond the authority of the agency, contrary to the intent of the legislature, arbitrary, or not necessitated by an imminent peril to public health, safety, or welfare, sufficient to justify adoption of an emergency rule. And that is a judgment call of the Committee on Administrative Rules. I can tell you from rules I've worked on historically, a loss of revenue to the state is not a sufficiently imminent peril. Failure to move quickly enough as an agency to get through the permanent rulemaking process is typically not sufficiently imminent peril to public health, safety, and welfare. Although if you are making reasonable efforts to do that and you aren't able to meet the 6-month period, the committee tends to grant a further emergency rule to cover the gap period. But in instances, for example, and I won't point out the agency here, but there was one agency that continued its emergency COVID rule for 6 further emergency rules. By the final couple of rules, LCAR objected to each and every one because they no longer satisfied that imminent peril COVID was passed, and the agency's excuses and reasons for why it was not able to adopt the permanent rule that it had been working on for more than 3 years did not satisfy LCAR. So that said, the objection does not prevent the rule from taking effect. It does grant more weight for someone who wants to challenge it in court. In that case, nobody was interested in challenging that emergency rule because it had simplified a process in the state. And something like inspections, where it's more controversial, or wetlands policy, something like that, you may have challenges. So the reality, though, in Vermont is there are very few challenges to the validity of rules, but an objection by LCAR shifts the burden of proving the validity of the rule to the agency. Normally, it's on the challenger. They have to prove that the rule is not valid. So
You have feedback if you have it?
I am in favor of simplifying the inspection manual, but not in favor of doing it through emergency rulemaking.
Well, I appreciate that. I do have to, for a second, at least think to reset the stage here in that we as a committee put off the legislature last year saying we would make sure the DMV came back with changes to the book and that there would be simplification of the process. And we committed in our miscellaneous motor vehicle bill last year and a discussion of the T-bills when we knew there were members that wanted an amendment to simplify the process. And I would have to almost argue to say that we asked them to do this. We asked the department to come back with a simplified program. So I love a good constitutional argument, and I'm all for having that more. What I guess I want to be, we go back now without using emergency rule. Emergency brings up all kinds of different views in people's minds of what is and is not an emergency. The agency's not the Agency of Transportation, Department of Motor Vehicles inside of it, not trying to deliver something that we didn't request. Okay, we started this and we've been on this path for a year and a half. We asked them to come up with a simplified book, and this is the fastest way to bring Vermonters relief. So I appreciate what is being discussed, and I'm happy to keep going down that path. But I do want to remind to set the stage. The committee is the one that asked them to do this work. The committee is the one that set the stage last year, saying we are going to get simplified inspections. We're even going to consider getting rid of them. We're going to ask all kinds of angles of what needs to be done. This is what they came back as a proposal from what, in effect, we asked them to do. So, and then they are by the administration putting forth a bill that says we want your permission to go ahead and do this. And still then, after 6 months, we'll still have the opportunity to change the rules. We're not really necessarily that far out of bounds here. Just as far as remembering the big picture of what we've asked to have done here. They didn't come here and say that, all of a sudden we want emergency to change this. We've set this stage last year saying, let's have a simplified book and we can perhaps spend more time on the individual items. I want to be careful about how far we're going down to this idea that somehow we're making a new precedent or a new emergency and we don't want to do it. If we go on the floor and say we're not bringing relief on the inspection for at least 6 more months, and then through the 8 months after that through LCAR, we are going to face some level of, we'll have to make sure we're ready to answer that, I guess is what I'm saying. Because we did in a way set the stage to ask for this. I want to make sure that's understood. So Representative Tomlinson?
Thanks. Yeah, I am, given how much this weighs on so many families, like I'm open to the emergency rulemaking process. And I think it's encouraging to me that there's still, that still opens the process for the formal rulemaking process. And I wonder if that might even spur more public participation in the rulemaking process, because folks, whether people are getting their cars inspected or mechanics will be more aware of the proposed changes because they're living through them and able to weigh in on the impacts. And from what I've heard, from folks at the DMV and from ANR, there aren't concerns that these changes would negatively impact public safety or our emissions restrictions. So I think I can support the emergency rule element of this. My main question would be how mechanics might handle that. I mean, that seems like it could lead to some challenges in terms of, adopting the new rules and system, and then 6 months later, likely dealing with some tweaks and like those communications. But that's I think one of my more significant concerns about this.
I do think that I should have added, and thank you for that. I appreciate it. Anyway, everybody should get a chance. That doesn't mean that I'm not willing to say that there are some things that maybe are abridged. There's some of them, perhaps like the road check that we may not want to agree to right now, but we're still going to do more work on it, I guess is what I'm saying. I just want to adjust to reestablish where we're at. Representative White and then Representative Powell.
Amy, could you just summarize again for us the two different timeframes? If we move ahead with the emergency rule versus if we decide that we don't feel comfortable with the emergency rule and the changes go forward in the normal timeframe.
So
Like, when is the soonest that changes could be adopted in each scenario?
sure. So under the existing language in the bill, they would be able to basically on July 1st, they would be able to adopt emergency rules. The bill requires them to adopt them on or before August 1st, 2026. So sometime in the month of July or no later than August 1st.
And that would
You would
be
have-
moving forward with the changes that the deputy commissioner reviewed with us yesterday.
That's my understanding, yes. So they would simultaneously adopt the emergency rules, which would go forward for 6 months from then. So through the end of January, I think that is, give or take. And then the goal would be that by the time the legislature is back in session at the beginning of next biennium, the permanent rules would be coming before LCAR. Although, again, if there are delays in that process, and sometimes you have particularly on something that sparks public interest, like inspections, you might have a really involved public comment period and a lot of work from the department to respond to those public comments. So they may refile the emergency rule at that point and then push out the timeline on the permanent rule. But from the date they file the permanent rule, unless LCAR grants an extension, they have 8 months to complete rulemaking. So if they file on, let's say, August 1st, they have to be done by, let me think, April 1st.
Okay.
Um,
So the emergency scenario would be
May 1st.
permanent rules in place
Um,
by April 2027. You're saying 8
That's-
months from August 1st.
Yeah, that would basically be by April of next year, permanent rules would be in place. And in the interim, what you've seen here, their draft rules would be in place. Plus or minus any minor tweaks that occur between now and then.
And the traditional non-emergency route has remind me of that timeline.
It's 8 months. So that's the 8-month timeline.
That's the 8 month.
Maximum 8 months from the date of filing unless LCAR grants an extension. So oftentimes though, there is before filing, there's a lot of work, which the agent or the department has been doing at this point. So that markup is the work that comes ahead of time before filing. And then from the time you file, you have 8 months to complete that public engagement process that's required for rulemaking.
In both scenarios.
With emergency rulemaking, you don't have to do the public engagement. It takes effect immediately, but 180 days after you adopt the rule, it expires. That's the thing. You can't do a permanent rule through emergency rulemaking.
But they still go through the LCAR process.
Still goes through LCAR review. LCAR can still object, and it does. So the most common instance of this has been the emergency housing program, which has been highly controversial. The administration and the legislature have not always seen eye to eye, so that has had on and off for years objections to both emergency and permanent rules. Sometimes they resolve and end up with a compromise. Sometimes the administration goes forward and adopts the rule. Frequently with the other emergency rules, there's more agreement, especially if it's on a less controversial topic, or if it's on something where the agency and the administration are on the same page. Go ahead.
And so one of the major changes is a public process or not a public process. And I guess it could be argued that there has been a public process already because the Senate had a joint hearing on this, not a joint hearing, a public testimony.
Public hearing,
Not on these rules.
not on these rules, but
Just
on
on
the
the-
issue. There also, it's worth noting in last year's legislation, you required them to set up essentially a hotline where people could reach out with concerns about the
Right,
process.
and we still haven't heard the results of that.
Yeah, so they have also gotten public feedback though, and I can't speak to what that feedback is. But so there has been some public engagement. But that's part of the construct in S326 authorizes interim emergency rules, but requires that permanent rulemaking public engagement process. So, and that, to give you a sense, we've done that in 2 other places already this biennium. And the emergency housing is not on this because last year in your budget, the legislature simply said administer the program pursuant to the rules you adopted last year. That's a long story, but you authorized it for the Agency of Human Services regarding the Medicaid program and the operation of the Health Benefit Exchange, as well as in relation to the Department of Health and food manufacturing establishments, which are basically home kitchens where folks are making food, smaller kitchens.
Was an emergency rule?
In order to get the rules adopted quickly, they did that as an emergency rule pending the adoption of permanent rules. So, and so that came in first as an emergency rule last summer. That went through LCAR review, and then a permanent rule came through later in the fall with some tweaks based on feedback that they'd heard. But they wanted, in both instances, they wanted to make sure that adjustments to the rules were in place right away to allow the legislature's intent to be carried out as quickly as possible. And that is often where you see this emergency rulemaking. The legislature is saying, we want you to do this from, next summer or this summer, but we also understand that rulemaking takes time. So we're going to authorize emergency rules while you do the permanent rules. And that's what you've seen in both of those instances. And the way this bill was drafted was to mirror that. Although the language is slightly different, but it basically to mirror that. The Senate was saying we want these changes as soon as possible. but we also want you to go through the public engagement process. So whether you want to move forward with that is up to you. So, yeah.
Yeah, I guess one last sort of comment, you know, to get to permanent, that happens all the time. To get the permanent rules, to get the permanent rules, you know, assuming no other sort of problems, it's only a couple, 3 extra months really, to get to the permanent rules one way or the other. And I would continue to argue that bypassing the normal process is not the best way to go. And, you know, our chair is suggesting we start picking which ones we want to go in. We're not experts. You know, I've said, hey, the test drive is, I'm really questioning that, but I've never inspected a car. So, you know, to decide whether that's the right way to go or not, maybe it is that we don't bother test driving. Maybe that's the right way to go. But I don't think it's up to this committee to make that decision. It's really have a public process and have the proper input, and then let the rulemaking decision process work through. And I think asking to go the normal process, here are the proposals, to go the normal process, is not an undue burden and be much cleaner than going the emergency way. Like I said, it's going to be hard to undo it. It'll cause more confusion for all the people who are both inspecting and getting cars inspected. Like, oh, I thought, oh, I passed this last time, now I don't pass. So I just think it's too messy. And I just don't see an emergency. Okay.
And I very much appreciate that, because that's why we asked him to spend an entire year to come up with a plan, to bring it to us, and then ask our permission to go ahead and put that plan in place that we asked him to put together last year. So we will have to pick that part up. I appreciate where you're coming from, and they've had a year. We have a year, we have recommendations. We'll have to decide if we're moving forward on them or not. As far as the bill itself, are there any other parts for the additional language that we had about education on the Smuggler's Notch piece, or the language on the texting, or whether we were able to thumbs up the flotation education piece, or the Smuggler's Notch education piece, or the A&R? Are there any of them that were a little closer? I think the texting piece came back. Are we any of the other sections that are still hanging out there that we might be able to thumbs up into the bill today? Or any of those you want to pick from, or any that I missed on? Has anything changed from yesterday?
So this is all the changes that you requested, but edited now. So this was and with the tweaks that you made yesterday. So,
Okay. I don't have a thumbs up against section 1 yet either. So,
yeah, so section 1 is these are the changes to bring our non-driver ID statute into line with the federal real ID requirements. I think I don't think I have anything to add. There was a fair amount of discussion about what the requirements were for real ID compliant versus non-real ID compliant IDs, whether they were currently doing this, et cetera.
I think I'd asked whether the members had others they wanted to ask about, whether they had any concerns. We're good. We're good. Okay. I don't know if we can bring it up or not. I don't know if we can bring it up as 326.
Absolutely.
And
That's the one under Commissioner Corrections, appointment powers.
yeah, we pulled out sections 2 through 6, left us with the section 1. There was discussion about
So
bringing this.
This is a new draft
requirements.
of your.
Make sure that people had a chance to check it out. And my understanding is people have checked it out, and this is not a controversial piece. It is a technical updating, bringing our Vermont state regulations in line with the federal requirements around ID.
Current practice.
And our current practice.
For folks who are trying to find this is a new draft, which should be posted to the website under my name for today. It's draft 2.1 because we went through 1.1, which is a rough draft yesterday. And this got edited overnight, and I made a few changes during our session yesterday. So this would be section 1. It's shortened from the prior version. Non-driver IDs, it's just the first half of the non-driver ID section from what the Senate sent over. It excludes the language that has now been signed into law by the governor in H 549. So to avoid any inadvertent changes to that language, we've just removed everything that was in H 549 and has now been signed into law. The big change here is an individual shall not hold an operator's license and a non-driver ID at the same time. You can have one or the other, but not both.
So I guess I would ask, unless there's any other reason to hold it up, does I get a thumbs up that we'd agree this section is good to go? Okey-doke.
Right. The next section that we had talked about was the smuggler's notch updated signage provision. This is on the bottom of page 4. And I don't think this has changed at all since yesterday. So this provides that the agency shall update signage leading to smuggler's notch to make drivers aware of the increased penalties for operating an oversized vehicle in smuggler's notch that are imposed pursuant to section 3.
That's just the new piece, all the rest of it stays. Yeah.
Everything else
We're already doing.
Yeah, nothing else has changed with the smuggler's notch piece.
I just have, I'm sorry, a question on the document we're looking at, because this is the new updated bill without, that has removed the,
These are just the change. Oops, sorry.
Yeah, this would be a draft of the committee's strike all amendment of what the Senate sent over.
so, because I don't see the pieces with the new fees for smuggler's notch in this section.
So you're you're looking at the as passed by Senate on your paper version. And then
Hold on, I'm looking at,
Right.
I'm looking at the document.
so if you look at section 3.
Pardon me, okay, yes,
yeah.
yeah, you're right, thank
So
you.
section 4 is just a new section separate from that.
I see it, I missed it,
Yeah.
because I thought that the highlighted portion started.
Right,
at
we're only
section.
looking at
Okay.
the updates since what we,
Right.
Yeah, and I
It should-
see, I see.
you're
it
right,
there
it should
above.
be in
Yeah,
there.
yeah, it's
It's not
there, it's
there.
just above what I was looking at.
It is.
okay.
Yep.
Above,
So-
so I'm all good, thank you.
Yeah, so section 3 has that, section 4 has the updated signage requirement. The only reason that's not in section 3 is because this is a sort of limited time, one-time thing, update your signage because we just updated the law. So we don't typically put that in statute, we just put that in session law. Salvage title language.
I'm sorry, I want to make sure, I don't have a thumbs up next to this section. Are we, is there any more smuggler's notch piece besides a field trip and a visit that we should? We're good with this, okay, so I can put 5-1 next to this, all right.
All right, salvage titles, the proposed change that came out of work between the insurance companies and the department, there was question about when, so the language the Senate sent over said an insurer shall indemnify and hold harmless the department for any claims arising from the issuance of a certificate of title pursuant to this section. And after a back and forth between the insurers and the department, they agreed on limiting it that to just the new electronically signed documents. So certificate of title based on supporting documents under the new section there. So that's the electronic signature documents. And that will include both a regular salvage title as well as a salvage title that's issued to an insurer after the insurer is unable to acquire the original certificate of title after reasonable efforts. And there's a process where the insurer has to make reasonable efforts for a month to try to get the previous owner to provide the certificate of title. And if they can't do that, they have to provide documentation of the efforts they made to the department. And if the documentation and the efforts are sufficient, the commissioner will issue a certificate of title at that point. And this is for total loss vehicles. So the insurance has been paid. The insurer has done everything they can, but after reasonable efforts, they cannot get the prior owner to provide a copy of the title. So, but in both of those instances, this will cover that if the transaction and the certificate that the department is issuing is based on electronic documents.
Was that change already there yesterday or the day before or not?
I think it was.
It's not new since yesterday, right? I think so.
I don't think so.
Okay, I think the reason I have a note that we were ready to go with this section already. But
Okay.
there is that change. There is no change since everybody, this is the agreed upon from multiple parties.
It is.
There has not been a change in this little bit that
Not that I'm aware of.
So I would say I think we are good with this then, because I already have a thumbs up note on the 29th. I just want to make sure there isn't anything changed since the 29th.
Okay.
And then
Section 16 on page 14. This is the handheld mobile telephone violations. The whole section is highlighted, but the change since you reviewed it is based on the testimony we got the other day, and that is found on line 2 of page 16. It's the addition of creating an exemption from the prohibition on texting if it's through hands-free use. And this is what Mr. Smith was talking about when he was testifying the other day. Now with the voice to text feature on most phones, you can now hands-free text through your phone and it will read it to you and you can respond, etc. So
it's the Reader's Digest version of this entire section. It says that we are updating the commercial language to match the way that the pleasure vehicle language currently regarding texting and hands-free operation in the state of Vermont.
that is correct.
We used to have passenger rules only. We want to update it to include how we handle commercial.
Right.
And
We had rules for both.
minus the two things that
We
federal
Interlock.
ignition interlocks. Yeah. Yeah. We had rules for both.
They can't be in it.
But the most recent updates were made to the pleasure cars only and not to commercial motor vehicles. And this brings commercial motor vehicles up to the same standards as pleasure cars, reflecting the advances in technology and so forth. And minus the ignition interlock, since you can't operate a commercial motor vehicle if you're required to have an ignition interlock device.
This update from the last time we looked at it is to verify the hands-free use.
Yeah. Yeah.
Everybody on the committee understand that, especially the person that's going to report this section? Are you picking out the sections you want to report this time? We're gonna assign. So I guess then I look around and say we're all good or not? Thumbs up on this section? We're all good?
Sorry, I was on my phone. I just had to-
Exactly. All right. Today's the 1st. Thumbs up. Okay. Now we're what personal quotation. Is there still the education personal quotation?
So the first is on page 22, line 14. This has not changed since yesterday. This is the clarification that a violation is not subject to the penalty. There was a correction. I had a typo in the section number. So I had 3318 yesterday. It's actually 3317. But other than that, the language is unchanged and it doesn't constitute a traffic violation. So we don't have concerns about individuals getting anything other than a written warning if they're violating the section. And then section 19 is the education piece that the committee discussed yesterday. The main change is the new language from lines 7 to 9. The outreach campaign shall include online and written information, which may be distributed to municipalities, retailers, and public and water safety organizations.
Move it down just a little bit.
Oh, sure. I'm sorry about that.
Sorry, I can't, or up the other way, I guess, to see the top of it. I mean, it's not
Better.
on the other way. You gotta go the other way. Yep, a little bit down.
Oh,
Get rid of the K part and this is the whole thing in one page. There we go.
perfect.
It's on there before. Since it starts October 1st and we're giving 30 days of it, so it starts November 1st, right?
Yeah. So there would be a month.
That's why we picked that day. The Department of Motor Vehicles and Public Safety. In council, so does the Department of Motor Vehicle have any comment about whether they're able to do this piece? You're gonna help coordinate a public outreach campaign on the update of this law by September 30th.
I think it's a little bit outside of our wheelhouse. Or is it getting them?
Who does do this work? Ben? I'm sorry, I lost it again, I made this up, yeah, we get to you, so. I don't think we can close this at this point then, from what I just heard, we're gonna have to take a look at that, and I'm. Excuse me. Ooh. Where do we go from here? And I'm not sure what I'm looking for right now. Got to stop.
What language? So.
This is on page 23, line 1. So it provides that the departments of motor vehicles and of public safety, consultation with the Coast Guard, Fish and Wildlife, Forest Parks and Rec, and Health shall develop and implement a public outreach, education and outreach campaign. And DMV has indicated that this is not, to quote, in their wheelhouse. So, and public safety, I believe, is who came in and testified. So you may want to just check with them on
The
this.
guy that was quite educated about all of this, he worked for, was he Department of Health, the one that was in charge of the aviation or the boat section, and he had a pretty clear.
He was
Have his card somewhere.
VSP. Is he not even part of VSP? I mean,
He was part of Department of Public Safety.
Yeah.
yeah.
So we may have this wording being a little bit.
Maybe we can ask him how he would do this. Does that make sense? Okay.
We're trying to support what they were talking about.
Yeah,
We're just not
but-
sure how we exactly do that.
Right, yeah.
I guess we're not gonna be able to thumbs up that section.
Make sure we have like a representative, like we're telling these people to do this stuff, which I agree with, but. We need an active.
We need to make sure who can do
Yeah.
it. We need to make sure
That's
who
right.
Who could do this?
Let's
Yeah,
invite a representative from each of
Somebody.
those departments. We can talk to them one after the other about.
or
the
just an
section.
email, I don't
Yeah,
know, just
even
an
email
email,
would
say,
be-
hey, fine with this.
I think good to
Yeah.
get a representative said, like I had said, I'd met the woman in the hallway and said, yes, what's the committee think of this? And she. It's not, but I said we were talking about just making it educational, not a fine. It's totally okay.
Yeah.
Yeah, that's the most important piece. That's what you work on.
So we're not, yeah, so how do
But,
we support the education piece of it? That's what we're trying to do. The
Yeah.
committee, that's the assignment of the committee.
Yeah.
They didn't ask us to do that, but we're adjusting the bill to say that we want to be more clear. So we need to go to these groups and find that out. Okay, so I'll move on from that from now, and we'll have to go pursue that.
All right. The next update here, and this is, I think we discussed this yesterday. I'm not sure if the language was in the version we looked at. 12 additional registration of not more than 12 additional limited use specialty vehicles per year.
And A&R, so they're not taking a position. Obviously, they don't want that. That's it for the whole section, 24, 25, 26.
No, with 25 has other changes.
Oh, that's right,
Specific.
visual inspection.
Yep.
And well, they're gonna have to either go in together or not, right? I mean, sort of.
Yeah. So 25 is the visual emissions inspection. But not,
Hear from that guy back about that change. Gotta find out who that was.
Yeah, he was in the room, so if there was an issue.
Oh, he was here yesterday.
One more time. Oh, you had it.
Additionally, thumbs up based on him. I'll find him, see what the scoop is.
Yeah.
Well, let me ask this. Committee is okay with this language or not, I guess is the question for these 2 sections or 3 sections. That it is 12 additional, and if we are now requiring, trying to line up with the antiques, the trade show, specialty vehicles, hot rods and all those, and you have side by side, we're trying to line up we want to know that there actually is an emission system, even though we're not testing the output of it. Okay, right, we want to be consistent, and we also are saying it is clarifying it's 12 additional each year. Okay, question?
I thought I heard yesterday that vehicles like this that are putting in these new motors that have to be up to federal standards will have an OBD system that can be plugged in.
Can have. There's an option. I think that's what
I thought that the guy from DMV who had been a police officer, who was here yesterday, because he had the OBD plug thing to show us, right? And I thought he said that if you've got a motor like that, it's gonna have an OBD system that you can plug in.
I think I would clarify that if you have a vehicle made in the current year, the motor itself put together with other parts doesn't have an emissions systems
Okay,
yet. I'm not a car person, but that's may sound real technical difference, but they're
Nor am I.
talking motor owner only. The motor itself will not necessarily have it, but they put the whole vehicle together with all the emission pieces that go on top when you make a new car. But we're talking about the motor only,
right,
that they're gonna pull
Yeah,
and
a
put
specialty
into the
car
car,
that isn't.
totally specialty car that was not being built with necessarily the emissions system, which is not part of the engine. Part of managing what comes out of the engine. A real,
You should have guaranteed everybody with a car in here would have to have that, with that plug would work on.
a vehicle, but not an engine.
Right.
See what we're talking about, they're talking about an engine that didn't get put into it.
right, okay.
I don't think he was aware of these 12 cars that we're
Right.
talking
But I
about.
also-
He was just talking about, general.
$600,000 car, right?
He was just saying, today's cars are gonna have.
To go into an approved vehicle that gets built for the entire thing and sold, it will have emissions. But when you just buy a motor, it hasn't
Yeah.
gotten all that other
Yeah.
part. The motor won't have any emission, does not have an emission piece to it, if that makes it. So you're gonna inspect a vehicle, yes, but this is not what we're talking about. We're talking about a motor pulled off of an assembly line of just motors. I think that's what the difference is. So.
So maybe the conclusion is the visual emissions inspection is the best we're gonna be able to achieve with these 12 cars per year.
Okay, are we good with this one, these sections? Is it 3 sections altogether
Yep.
on specialty vehicles? It was 25, 26, and 27, but the new numbers are almost, not quite, but they're near the same.
and getting closer, yeah. as you added individual sections in the middle, it's worth noting too, for the limited use specialty vehicles, it potentially captures instances where you have older vehicle that is restored and modified. So that can include taking older engine and older vehicle and then extensively rehabilitating, restoring, and then making modifications to it. Whether that might include a modern engine inside an old frame or a modern frame with an old engine. There are varieties to this. The company in Milton, my understanding is that's new engine, new body. That's essentially a souped up replica of an old car, but there are others where they take old bodies that are clean them up, and then refit them with modern suspension and electronics and all sorts of stuff. So there is a spectrum of these vehicles, and some of them may have engines that predate the OBD systems.
And maybe putting out some good emissions.
Yes. So similar to the antiques and the street rods, where they may have exhaust systems that meet the requirements of the year they were manufactured, but don't meet the requirements for like a 2026 exhaust. Yeah, and that's what we require for the street rods and the antiques or that's what the EPA requires for them, is that they meet the emissions requirements for the year they were manufactured, which in some cases are not, because they predate the Clean Air Act. Yeah.
Okay,
All right.
we're done for today. We are adjourned. We are back on Tuesday. Field trip is